Well, speaking of awful and things that are unconstitutional, let me give you the backstory here. And I'm not as worried about the merits of this particular case because we don't know much about it. But the core First Amendment issues, that's your thing, and that's why I want you here. So, Aidan Kearney, who's been assailed by many folks who are not happy with him for whatever reason, he's not shy. And so he may say things that upset people. And there's been apparently, and this is new because it's been squashed by the court to the degree that it's not even supposed to be talked about by the defendant, Aidan Kearney. But an individual, and this was filed in Atlantic City, which is the county of Atlantic, an individual claims that he has said something about her, we know it's a her now, and or her family in a way that she didn't like. I don't know, hurt her feelings, something. She goes to court and asks for, as anybody can, basically a temporary restraining order. Please don't let this person bother me. Now, normally it would be prohibition against physical contact or phone calls or anything that is a direct contact. I don't believe social media is a direct contact, but that's maybe someday it will be, John. I mean, who knows? But at this point, it needs to be more aggressive and more traditional in terms of contact. So that gets elevated, I'll use that word, to what we're going to look at, which is the newest provisions in that order. And there's been no hearing. That's another issue. This came about on November 5th. Okay. So a couple of days from now, that'll be 10 days. Tomorrow's Friday the 14th. So it's not going to happen within 10 days, which is statutorily the theory. And why? Because it's temporary. And it's such an infringement on your rights that it should be in front of the court as soon as possible. Well, it hasn't happened yet. And now this is the latest version of the other relief. Whoops, too much. And this was published by Aidan Kearney. As I say in the title to our show today, he's thrown down the gauntlet because as we read this, it looks to me like he's saying, oh, yeah? Other relief. And again, this is part of the temporary restraining order. Other relief. Defendant to immediately remove any and all social media posts referring to plaintiff and family members, specifically any reference to plaintiff family members, any personal information or court-related issues or documents to be removed immediately. Failure to do so is a violation of this order and an arrestable offense. Any further posts referencing plaintiff family, town, work, or anything else is a violation of this order and arrestable defense. And that's signed, the hearing officer, I think, sends it up to the PJ, which is Rodney Cunningham. Good work. Great work, dude. I see nothing wrong with this, John. It seems to be perfectly reasonable.
Oh, man, this is so awful. This is what they might call in the First Amendment law a prior restraint.
Yes.
A prior restraint is basically what it sounds like. It's where a court or legislature or a government body, before you even say something, says you can't say it. And there is a very famous case going back to 1931 called Neer versus Minnesota. And it was a Supreme Court case that basically struck down these kinds of things in a very famous decision. And one of the things was that this kind of idea that you can pass a law or a court can state you can't say anything in the future about this is, almost alien to American and English law, which is where we call it Anglo-American law. We get our law from England. It said that the fact that approximately 150 years of the country, there's an entirely absence of attempts to impose previous restraints upon publications, quote unquote, is significant of the deep-seated conviction that such restraints would violate a constitutional right. Basically, in Neer versus Minnesota, it was a similar case to this. The situation was they used a law that said no defamation or malicious publications to completely shut down a newspaper. They said, well, in the future, you're going to publish something very scurrilous, so we're just going to shut you down. The Supreme Court said you can't do that. You can sue them for things they have said, but you can't say, well, you're a bad person. You're not allowed to talk anymore. And they were actually right, because the publication was publishing a lot of things about, at the time, the intertwinedness of politicians and bootleggers, because they were all on the take from bootleggers in Minnesota. It was coming down from Canada and getting to American cities that way. So that's a classic prior restraint. The government can't tell you what you can and cannot say in the future. It can only punish you for things you've done in the past. And this last sentence, that was the first thing I noticed about this. Any further posts referencing the plaintiff or the plaintiff's family, the town, the work, or anything else involved. Look, you may not like him, folks, but Aidan Kearney is a journalist, okay? He is protected by the First Amendment to say that, those kind of things. I don't know how the town or the work or anything.
I don't either.
Or the plaintiff's family, I will say. I'm not licensed in New Jersey, so I can't speak about what plaintiff's family is defined under the law there. But in most restraining order cases, it's only applicable against the plaintiff. The plaintiff gets the protection, but not the entire family. How is it like your third cousin? You can't talk about him. And the second thing is, we don't know the context. If he's actually reporting valid news, and he's not, this isn't a personal matter. And again, there are kind of exceptions if it's like, two people who have an intimate relationship and you're being nasty back and forth. Sometimes they can restrict that. We've seen gag orders in various cases, criminal cases. Even the president was gagged in his case. But this is just so ridiculous to shut down a person who is clearly a news maker and a news reporter from ever speaking about whatever it is they're speaking of. It's just, I hope he's got his First Amendment lawyers ready, and I hope they're ready. They're chopping at the bit. I hope.
You may know at least one of them, Linda Kenny Bodden.
Oh,
which is why she's on assignment, and also Darren Gelber, who he's a New Jersey lawyer as well, very very well respected. He used to come on Law and Crime when Linda and I were both there. He used to be a guest on there, so he's got the firepower. It doesn't make this any less ridiculous. It may make, and I'll give you my thoughts on this and tell me your experience with court dockets. My biggest concern is that this is at the TRO level. This is not like there's been a big evidentiary hearing where they've ferreted out what the issues might be and the seriousness of whatever the allegations might be and proven them true. Therefore, boom, here's what we're now going to do to remedy the situation. This is so out of control, so far ahead of any fact finding. You can just say whatever you want, and this judge or the office, and then rubber stamped by the PJ, will just say, okay, fine. Okay.
Look, and I'm sorry to say, I again, not licensed in New Jersey, but having a lot of experience working in restraining order cases and harassment order cases, which are very similar. You see, this is actually going to be a big constitutional area of law going forward, because there's nothing wrong with restraining orders and harassment orders to protect people who are in need of them. However, the problem becomes many of them, again, grant protections without a hearing, or tend to rubber stamp them, especially in certain demographic circumstances. And then there's the question of, like, some of them are massively overbroad. For example, here in Massachusetts, the restraining order and harassment order language, if you read it strictly enough, it would actually prevent the defendant's lawyer from actually talking to the plaintiff's lawyer, because it says any agents, and any attorney is your agent for the legal circumstances. Now, I don't know anyone who's ever been prosecuted under that, but the language is so overbroad that it prevents these sorts of things. And in this situation, this just seems like they're given out like candy in many circumstances. There needs to be a lot more restrictions upon them, in my opinion. Otherwise, we're going to get huge constitutional issues like this going forward. It just shouldn't be. And again, this was done in New Jersey. Kearney is clearly a Mass. I won't say the term, but he's a Massachusetts resident. I don't even know if you don't get notice of these until after they're passed. How is he supposed to get there? And thanks to VAWA, these kind of things are given full faith and credit. So Massachusetts must recognize this under VAWA law. If this is a romantic situation, or this is a female doing it against him, which I believe you said it was.
It's very fuzzy, but we do know it's a female complainant or plaintiff. And it's obviously Aidan Kearney defendant. So your description there of Massachusetts doesn't surprise anybody that that they would have a law that's written so broadly that it really shouldn't even be enforced, and perhaps maybe they haven't and won't ever enforce that. But that makes perfect sense in Massachusetts. One of the other things I thought was interesting is this was on calendar for yesterday. Okay, the reason these TROs, I'm not telling you anything. The reason these TROs are so short is because you're infringing on somebody's rights. Therefore, let's get it in front of the court as quickly as possible to find out if it's valid or not. If it's not, we'll get rid of it. If it is, we'll enforce it, maybe for a longer period temporarily, maybe for permanent. Who knows? A lot of these, domestic violence type cases, they make them permanent, and it's a violation for the party to break that restraining order, and that would be arrestable. But you got to get in front of the court. You can't just leave this temporarily dangling out there, because at what point does temporary become more than temporary and further infringe on the person's rights? So there's a hearing yesterday that last minute is pulled off calendar. So we're busy. We're just busy. We're just way too busy. Now, if I'm looking at, tell me your experience with the docket. I'm looking at a number of matters on the docket, and there's only so much time, so much court time. Wouldn't a TRO be pretty high up the list of things that you should be addressing?
It should be. And this is another problem with restraining order matters. For some reason, at least, again, not licensed there, but in Massachusetts, where I've handled a number of them, they can often be put at the back of a line. First, obviously, would be criminal arraignments. That would be the most important for people who are arrested. But, I mean, it definitely should be bumped up ahead of time, especially one that's about to expire. And especially one that so restricts First Amendment rights. I think the part of putting this to the back of many, to the back of the line in many of these circumstances, is the idea that they'll just by not handling it on a certain time, it gets extended, or we have to have it for another day, or we have to come back in 5 days because the court is very busy, and so now it's a 15-day TRO. And I have seen situations like that where it's been extended because one of the parties can't show up, and if the plaintiff can't show up on that TRO date, they will extend it in a restraining order matter, at least up here,
which to me is also a flagrant abuse of the system.
Right, it's grossly unfair. I mean, if you really were the kind of person playing with this falsely, just keep making excuses, claim you're in the hospital, and then you get a free month before you have to actually, and then hopefully when you come back, the defendant is so busy working, which has happened in my cases, that they can't show up. Or their attorney. I've had cases where I will show up for defendant, but the defendant has to work that day. And I said, Your Honor, I'm here to contest this, and this person can take the day off. And they go, well, if he's not here, I'm just going to deny your motion to vacate. I'm just going to grant this for another year. And I go, Your Honor, my client just can't be here for, we don't need to, he doesn't have to be a fact witness. So I'm just going to argue the law. Nope. And we get shut down like that. And it's very, very disheartening. And restraining order law needs to be reformed. That's all I have to say.
And the thing that bothers me most about this is, if you put in the context of a normal TRO, as I mentioned right off the top, it's a no contact usually. That's far less onerous. Okay, we got to put that off for a week where you're going to contact the person anyway. I mean, in most cases, that TRO comes in to kind of cement the situation that's already in play. They don't have a lot of interest in one another, unless you have a harassment or a stalking kind of situation. So to extend the no contact, far less onerous than don't do what you do for a living, which is basically what this is saying. Don't do reporting because, we couldn't get to your case. That to me makes it even more outrageous.
Right, and it also muddies the waters in many cases, because you can be darn sure that in many cases the plaintiff, whoever got the restraining order in the first place, is telling everybody in many cases about what their perception of the other person is, and sort of hurting their reputation, perhaps even brigading or getting allies, whereas the defendant in these cases, if this kind of order is in case, it can't even say, I can't even say the person's name, can't even say what's going on. And so it creates a social dynamic. And again, these are two separate people in two separate states, but if people are living in the same town, one's bad-mouthing the other one's not saying anything, people start to make conclusions. And unfortunately, that the social harm that causes to a reputation of defendant, completely legal as of right now, is very detrimental. And to sort of bar you from being able to say, I didn't do this, she's got the, or he's got the restraining order, but I didn't do anything they said. I think that causes more social harm in an attempt to protect potential plaintiffs. Again, the goals here are noble, but the enforcement, as many people can tell you, can be so wonky as to injure you for life, mentally and emotionally.
So let me bring this back up. This is the order. Just to give folks a refresher for those who were not here right at the beginning, we had John Mateus, who was a First Amendment attorney. An action was filed, ex parte, single person plaintiff, complainant, because it is technically civil, a complainant, files this request for a temporary restraining order against Aidan Kearney. Okay, don't know what generated it, don't know anything about that. It's all sealed up. And again, further disclosure, Linda Kinney Bodden is representing Aidan Kearney, as is Darren Gelber. We have not been in touch with any of this, so I'm just sussing it out from what I see and hear elsewhere. The person goes in, asks for a temporary restraining order, which in normal context means don't come near me, don't call me, don't contact me. It's a no contact type of order, and it's short term. It's short in duration because you're stripping somebody of their rights. Let's get in front of the court. A little due process would be nice. Let's make sure that before you deny somebody these rights, you've got the goods, okay? Well, before that even happens, there is an attempt to have the matter heard. Aidan Kearney shows up on his own, unrepresented, and the next thing he knows, he gets an updated temporary restraining order, which includes this number 6, other relief reference. Defendant to immediately remove any and to immediately remove any and all social media posts referring to PLA and family members, specifically any reference to PLA family members, any personal information or court-related issues or documents to be removed immediately. Failure to do so is a violation of this order and an arrestable offense. Any further post, okay, so now we're talking about things that have been done. Any further post referencing PLA, family, town, work, or anything else, that's not too broad, is it? Is a violation of the order and arrestable offense. Hearing officer rubber stamp, Rodney Cunningham, presiding judge rubber stamp. And so you get this mega order now in place. There's been no due process. There's been no hearing on the merits. There's been nothing except this edict from the court saying, not only are you being prior restrained from your First Amendment right to report on, talk about these things, but you have to cleanse everything you've already posted. That is such crap. It is so overreaching and so unconstitutional that it just makes me want to puke. So he's got help. We'll see what happens as this thing moves through the process. They have yet, as far as I know, gotten a hearing date. So this temporary restraining order, becomes indefinite until they get a date, and it will be very quickly extending the 10 days. You can see this updated order was November 5. So that's almost 10 days. But in fact, the original predated that. So we're past the 10 days from the original TRO. This is the now new and improved extended TRO. And we're going to be past that date by Saturday. Nothing happening tomorrow. If it does, obviously we'll bring it to you. But that's where we are with this latest extravaganza against Aidan Kearney. And for those that I don't give a rip, those that are so, Aidan can be a divisive guy. I get it. Fine. Don't like him, I don't care. This is the First Amendment case. For those who were anti-Karen Reed, and I filed the lawsuit against Massachusetts State Police, I was doing it for you too. And he's fighting for you too. Anybody that would like to speak their mind and do so legally under the First Amendment should have the right to do it. And when people like Aidan Kearney stand up, or I stand up, just say thank you and get the hell out of the way.